It's back to square one for Jaypee Infratech's lenders. The Supreme Court has ordered fresh bids in the insolvency proceedings, which means that the 180-day period actually begins today. Arpan Chaturvedi first joining us with what exactly happened at court. Arpan.
That's right, Ira. So this was basically the court hearing the petitions which were filed by some of the home buyers. When in August last year, the NCLT Allahabad had admitted the insolvency petition against Jaypee Infratech, which was initiated by IDBI Bank. After that, some of the home buyers had approached the Supreme Court saying that that process does not include their interests, and had asked the court to intervene, the top court to intervene. After that, of course, we saw the Supreme Court ordering Jaypee Infratech to deposit 2,000 crores, Jaypee Associate, beg your pardon, to deposit 2,000 crores. And of course, later in this year, we have seen the amendments in the Insolvency Code where home buyers are now equivalent to secured creditors. So that happened in the Parliament. Apart from that, as far as today's case is concerned, there are four major directions from the court. Number one, that the Committee of Creditors has to be reformed and made again. The 180 period, of course, as we have informed, begins today. Apart from that, they have also said that the Jaiprakash Associates Limited, the holding company of Jaypee Infratech, will not be part of this particular process as far as the insolvency of Jaypee Infratech is concerned. Apart from that, they have also the Supreme Court has also allowed the Reserve Bank of India to direct, if it wants, the insolvency proceedings against Jaiprakash Associates as well. So these are some of the main pointers of this judgment. Of course, now it is again after a year back to the NCLT bench of Allahabad to take forward this insolvency case against Jaypee Infratech.
Arpan, thank you for that. The ruling also has larger ramifications on the entire insolvency and bankruptcy process. The decision to start afresh throws the entire 180-day deadline off track, with the process almost starting from scratch. Vishwanath is here to explain how this may influence other cases. Vishwanath.
So we've seen, multiple cases where judicial bodies, the Supreme Court or the NCLT or the NCLAT, all giving extensions wherever they feel that probably beyond the 270 days, this case deserves another 60 days. It was decided on a case-by-case basis. Here, the peculiar aspect is that the entire process will start from scratch, which means that ideally the case should have gone into liquidation because the 270-day period has ended back in May. Yeah. So, the case was put on hold by the Supreme Court all this while. Now that the whole process starts again, it throws up a lot of questions in terms of, how exactly do you approach any other case? In this case specifically, they're talking about home buyers and their rights, and therefore the Supreme Court had to step in and sort of help them assert their right. Prior, in their order, the Supreme Court mentions that prior to the 6th June amendment, there was absolutely no mention of what home buyers are supposed to do in a situation wherever, a company takes over, a company goes into insolvency, even though their rights had to be respected. But yeah, in the order they've said that since there has been a change in the intent of the legislators, that home buyers should be given a right, should be given a chance to assert their right whenever there is a company in insolvency and they have pending property. They're doing that now.
All right, Vishy, stay with us and join the conversation. Ajay Shaw, partner at DSK Legal, is joining us on the phone line. Ajay, good afternoon. Thanks for taking our call. We were just talking about whether there are wider implications of the Supreme Court's order in terms of the timeline, the 180-day timeline. How do you see it?
Okay, I think as far as, this is an issue which the Supreme Court has exercised its power under Article 142, which is more an exceptional power given to it. And to answer the question whether 180 days timeline is going to really be impacted, I think this should be treated as a case which is one of instance, is an exception rather than the norm. And the reason for that is the peculiarity of the situation. And just to substantiate that, you have a situation where you have a huge number of home buyers, of which 92% of the home buyers in the current matter actually want their property back. And if this company were to get into liquidation, while under law in the IBC, they have been recognized as financial creditors, in liquidation proceeding, if the assets were to be monetized, they would technically be the ones who would be absolutely left in a hopeless situation, because as per the waterfall, they are not going to be treated as secured creditors. And that would really have created a very grave situation for the home buyers. And I guess this is precisely the reason why the Supreme Court has avoided a liquidation and is extending the timeline. Though, there were arguments made as to whether the 180 days extension should be outside the purview of IBC. I think that would have left a lot of other questions which would have been opened up. So therefore, given where it is currently, the Supreme Court's action, to my mind, is more on account of the social requirement in context of the home buyers.
Ajay, Vishwanath here. Just wanted to ask you this question about what exactly this means for, let's say, any other case. I mean, in this case, there's home buyers, but there are plenty of small business people in other large cases. And what about their rights, and what would happen there if the 270-day period were to run out and cases go into liquidation?
See, Vishwanath, there are two aspects over here. One is the 180-day period itself, which in fact, we all appreciate that the timeline is very critical and that should be really respected. There was already an extension of 90 days and there should be no further extension as mandated under the law. But this situation, if assuming that this company were to go into liquidation and there was no question of resolution, then in this particular situation, what would have happened is the asset would have been sold. If you look at the waterfall under Section 53 of the IBC, the money would have gone to all the secured creditors, and by the time if there was anything left for the home buyers, it would be very minimal. And therefore, the protection of the home buyer, whether in the form of getting some money, would have been ruled out, and even getting the property would technically be a very unfeasible option then. So I would not say that, they should try and have a bearing on other matters unless there is a social issue of such magnitude. Because ultimately we need to respect that IBC is an economic legislation, but, wherever there is a social element, it has to be taken into account wherever the need arises. And this is what possibly the Supreme Court has done.
Ajay, sorry to interrupt you. Just wanted to ask this question. Who exactly determines what is a social issue of a certain magnitude that needs the intervention that has happened in the Jaypee Infratech case? Who decides this?
This is something which the Supreme Court has exercised its inherent powers under the Constitution itself under Article 142.
Okay, so at the end of the day, it's a call that the Supreme Court has to take. So if any case were to go there, then probably they would decide on what is the magnitude.
Correct. And again, I would caution everybody, it's more an exception rather than the norm. This should not be used in a manner to defeat the whole purpose for why IBC has been introduced.
Ajay, but then in that case, you don't think that if this particular case had been done outside of the IBC, it would have prevented the confusion? The Supreme Court could have taken note of the exceptional circumstances that you just talked about, but did it then, could it not have been then taken out of the IBC process?
So in fact, this was the argument made by Mr. Nariman that it should be allowed outside the IBC, and that would have actually allowed, the promoter company itself to also be able to participate. But I guess the Supreme Court has respected the purview of the IBC in context of ineligibility of the promoters who were otherwise disqualified under 29A. And that is precisely the reason they did not allow this proceeding to continue outside the IBC under the concept of debtor in possession.
Okay, Ajay, I understand this is a peculiar case and that the larger issue of home buyers need to be considered. I have a hypothetical question. If this bidding process does not yield in a resolution, and if liquidation is the only way forward, then what happens?
In that case, say if there is no resolution possible, then, ultimately there is only one solution to it, is the liquidation. But let us now just again play this entire factual narrative. The fact is today the home buyers will get on board. That will change the voting percentage. As far as the home buyers have been clearly recognized as financial creditors, they participating in the COC. They will technically try and push for only two things. Either they get a money which is acceptable to them, or they will, try and get a resolution accepted which contemplates possession to them. In fact, the earlier resolution was, not accepted by the lenders. The reasons the reasons could be several, but in this situation, the home buyers will have a same context of, trying to push a resolution. If they themselves cannot push a resolution, then technically the fait accompli would be a liquidation.
All right, Ajay, interesting case, and like you said, perhaps a one-off. Thanks so much for joining us with your quick views that played out in the morning. And you can go to bloombergquint.com and read more about that story.